An order of this Honorable Tribunal granting leave to the second respondent applicant to bring and argue this application before, from outside or during the pre-hearing session. Two, an order of this Honorable Tribunal striking up grounds 1 and 2 contained in paragraph 16 of the petition for being incompetent. Three, an order of the Honorable Tribunal striking out paragraph 17, 18, 19, 20 to 29 of the petition, which are predicated on the incompetent grounds 1 and 2 in paragraph 16 of the petition for being an abuse of court process. And order 4, an order of this tribunal striking out reliefs 1 to 7 of the petition for being incongruous, illogical, and ungrantable. And 5, an order of the Honorable Tribunal dismissing or otherwise striking out the petition for one of jurisdiction and on the ground that the petition does not disclose any reasonable course of action. Here's the grounds stated here in, and good night. I've considered the arguments of counsel, which I've summarized in the ruling. It will be seen. It will be seen that this application is premised on several grounds. The first is that the grounds of the petition are incompetent. This is premised on the erroneous argument of the second respondent or applicant that the grounds for the petition are stated in paragraphs 15 of the petition. A careful perusal of the petition will disclose that there is only one ground for the petition and is stated in paragraph 15 of the petition as follows: that your petitioner states that the ground upon which this petition is presented is that the third respondent was at the time of the election not qualified to contest the election. The averments in paragraph 16 as unequivocal caption deal with the facts of the petition. This ground for the objection to the competence of this petition therefore lacks substance, accordingly discountenance. The second ground for the objection is that the petition is an abuse of court process. It is premised on the fact that the petitioner's respondent had earlier instituted an action before the Federal High Court in suit number FHC/ABG/CS for 1,415
George voice the crack. George voice the crack.
And INEC and 12 others.
George voice the crack. We don't understand. George doesn't speak English well. George, your voice the crack. Speak well. They talk like say kata de your voice. Kata de George voice. Kata de George voice. Which one they stutter? They stutter. Make him talk well.
Who referred the matter to the Court of Appeal for interpretation. That in any case, the matter had since lapsed in 180 days for determination by law, being a pre-election matter. It is tried law that abuse of court or judicial process simply means the use of a court process or in bad faith to the annoyance of the opponent. One variety two will show that the same was instituted in the Federal High Court, Abuja, on the 27th day of July 2022. Three matter is what to have been determined within 180 required by Section 285, subsection 10 of the 1999 2023. About a month, the election in question was conducted. This petition having been instituted on the 20th of March 2023, when suit number FHC was no more alive, does not qualify as an abuse of court process. This ground for this objection is also pronounced. On whether this petition is caught by the doctrine of estoppel, it was argued that the issues raised in this petition have been firmly resolved by the Court of Appeal in appeal number CS/ABJ/CS/08/2022. Issue estoppel arises when the issue has been decided upon to finality by a court of competent jurisdiction. In other words, once an issue has been raised and distinctly determined between the parties, another party can be allowed to fight that issue all over again. The same issue cannot be raised by either party, again in the same or subsequent proceedings, except in special circumstances.
Open up.
For issue as to apply,
Open.
the following conditions must be satisfied. A, the question must have decided, the same question must have been decided in both proceedings. B, the decision which creates the obstacle must be final, and the parties to the decision or their prelude to the proceedings in which the obstacle raised must be the same. To determine whether the above three elements exist, the court will closely examine the reasons for the judgment and other relevant facts that were actually impeached in the proceedings. In the cases of Wahala and others are Muslim, OSPM Limited was Nigel Company Nigeria Limited, and Dasuki retired was Federal Power Nigeria, I've studied the case so to be relied on as acceptable in this case. It's apparent that the parties in that case are not the same as in the instant petition. The issues, though the same, were not resolved to finality in the previous case. The action was struck out on ground of lack of local standing by the lower court, which this court affirmed on appeal. Thus, the objection on that ground is also discontinued. On whether the question is statute barred, I had held in the earlier motion filed by the first respondent on 7th May 2023 and third for the respondent's motion filed on 12th May 2023, which were taken together. This petition, which is premised on the nomination or sponsorship of the fourth respondent, is a pre-election matter. That being a pre-election matter, it ought to have been instituted and ventilated by the petitioner before the Federal High Court within 14 days from the date of the occurrence of the event or action complained of. That not having been done, the course of action in this petition stands barred by virtue of Section 2859 of the 1992 Constitution of the Federal Republic of Nigeria as amended. On the issue of local standing, I have also held in the previous motions filed on 7/5/23 and 12/5/23 that issues of nomination or sponsorship of candidates by political parties for an election come under pre-election matters. It is settled that the issue of nomination of candidates by substitution is purely a pre-election matter. The only person with the local standing to challenge the nomination is an aspirant who participated in the process of such nomination. In other words, apart from an aspirant who took part in the primary election, no other person is authorized to challenge such nomination by a political party for an election. That process of challenging the nomination is sanctioned by Section 84, subsection 14 of the Electoral Act 22 and 285, section 14 of the Constitution. Tishin Kafi and another versus Abdul Aziz Ayari and Al Hassan another and Ishaku. Therefore follows that the course of action in this petition, which is rooted in the nomination or sponsor of the fourth respondent, is a pre-election matter. Being a pre-election matter, the petitioner herein has no local standing to challenge or question such nomination or sponsorship of the fourth respondent by the second respondent. Thus, in People's Democratic Party (PDP), an Independent National Electoral Commission and others, unreported decision of the Supreme Court, delivered on 26th day of May 2023 in SC.CV 501.2023. I had the matter has been reported, but I have not been able to avail myself of the report. Then at the Supreme Court held at page 71 at follows, page 31 lines 1 to 16 thereof as follows. Quote, a provision does not make the filing of pre-election matters by political parties an all-comers affair. It is not the purpose of the provision that the floodgate of pre-election litigation be open to political parties who will hide under it to challenge the action or inaction of rival political parties under the guise of challenging the decision or activities of panic. The application of Section 285, Section 14C of the Constitution does not extend to a political party poking into the affairs of another. The position of the law has always been that no political party can challenge nomination of the candidate of another political party, no matter how pained or disgruntled the political party is with the way and manner another political party is conducting or has conducted its affairs concerning its nomination of its candidate for any position. It must keep mum and remain an onlooker, or it lacks the local standing challenge that nomination in court, close of court. It is clear, therefore, that a political party such as the petitioner sharing only have the local standing to file a pre-election matter when the situation affects it or its candidate by virtue of Section 285, Section 14C of the 1999 Constitution. That being so, as in the instant petition, where the grounds of the petition is rooted on the nomination or sponsorship of the candidate of another political party, this petitioner will have no local standing to institute the action, be it in the Federal High Court or an election tribunal. In this petition, being on the nomination and sponsorship of the third respondent applicant, the petition is incompetent for lack of when the petition to dispute the action. It is also liable to be struck out for being incompetent. The second respondent applicant also contended that the petition is not properly constituted as the candidate sponsored by the petitioner has not been joined as co-petitioner in the petition. The short answer to that is that Section 133, Subsection 1B of the Electoral Act 2022 entitles a petition as a political party to institute an election petition. The applicant has not referred out to any provision of the Electoral Act or any authority that mandates the political party to file an election petition only when its candidate has been joined as a co-petitioner. It is true that it is proper for the candidate of the party to be so joined, but there is no law that compels the political party to join its candidates in the petition. After all, the purpose of such joinder is so that the candidate can be bound by any judgment or order of the court or tribunal, but any non-joinder will not invalidate the petition. This is particularly so when Section 133, Subsection 1 of the Electoral Act stipulates as follows. An election petition may be presented by one or more of the following persons: A, a candidate in an election, or B, a political party which participated in the election. By the use of the disjunctive word "or," it means that an election petition may be filed by the candidate alone or the political party or both of them. The objection on this ground is also disconcerting. Another motion filed on the 15th of May 2023, the fifth respondent, thus Kabir Masari, prayed this court to grant him the following reliefs. 1. An order of divisional court dismissing this petition in its entirety for one of jurisdiction. 2. An order striking out the name of the fifth respondent applicant from this petition for non-disclosure of any reasonable course of action against him. And first, other orders are this honorable court may deem fit to make in the circumstances. The grounds for the application have been stated. Have also considered the submissions of counsel. Now, Section 133. Section 133 of the Electoral Act defines persons who are necessary parties in an election petition. Generally, necessary respondents in an election petition are the persons whose election or return is complained of and the electoral body that conducted the election. This Section 133, subsection 2 and 3 of the Electoral Act 2022. Those are what are termed statutory respondents. It should be remembered that election petitions are sui generis. As sui generis, and its procedure is strictly regulated by statute. That's why a person does not fall within the category of statutory respondents. They are not registered parties in an election petition. See the cases of Agbere and Nimra, Buhari and Yusuf, APC and PDP. That's in Waziri versus Begum. The Supreme Court held a court. From the above, I have no difficulty in going along with the submissions of the respective counsel for the respondent. That Section 137, sub 2 and 3 of the Electoral 2020 has no room for the joinder of the fifth respondent who neither won the election nor performed any role as electoral officer or agent of the third respondent in the election petition, challenging the result of such an election. And even no relief was claimed against the said fifth respondent, and indeed, he had nothing to gain or lose in the petition aforesaid, close of court. Indeed, a holistic reading of the facts of this petition does not disclose any complaint against the fifth respondent. The only fact that relates to the fifth respondent relevant to the petition is the act of withdrawal of his candidacy as the running mate of the third respondent. That is an act that occurred within the pre-election period, therefore cannot amount to any act done by the fifth respondent at the election. It cannot therefore ground any complaint by the petitioner against the fifth respondent in an election petition. It may be relevant in a pre-election matter, but not in an election petition. It is therefore my finding that there is no any claim on the fifth respondent. Otherwise, the relief sought in the petition will not in any way affect the fifth respondent, as he did not participate in the petition either as a candidate or agent of the second respondent, and no declaration was made in his favor by the first respondent. In that respect, I hold that the objection of the fifth respondent on this ground has merit. Finally, I order that the name of the fifth respondent cut out this petition. These are the rulings in respect of the petition number 4. I will now go to the main petition itself. So after the pre-hearing session, hearing on the petition opened and closed. Witness attended some documents from the bar, and the petition was adjourned by docket or written addresses. Parties then filed on self-written addresses as directed by this court, and same were adopted on the 14th of July 2023. The matter was then adjourned for judgment. The first respondent's written address was filed on the 30th of June 2023. Therein, 4 issues were raised for determination as follows. 1, whether considering the facts of the petition and evidence laid thereon, the petitioner has the local standing to question the nomination of the first respondent as a ground of challenging the qualification and the term of the third respondent as the winner of the presidential election 26 February 2023. 2, whether having regard to the facts pleaded and evidence laid thereon, vis-a-vis the provision of Section 134 subsection 3 of the Electoral Act 2022, and the issue of validity of the nomination of the first respondent as the vice president candidate of second respondent is validly raised as a ground before this honorable court, question or challenge the qualification and term of the third respondent as the winner of the presidential election of 26 February 2023. Number 3, if the answer to note 2 is in the affirmative, whether having regard to the facts pleaded, the nomination of the first respondent as the vice president candidate of the second respondent is void, as to render the third respondent not qualified to contest the presidential election of 26 February 2023. Or whether considering the relief sought as per the petition accrues no utilitarian benefit to the petition not an abuse of court process. Well, to save time, all the other respondents filed briefs and raised issues. These issues have been introduced in this judgment, including the issues raised by the petitioner.